what can an alleged victim argue to improve their chances of getting a no contact order dropped? Oftentimes it's very frustrating if you're the protected party and you don't want the no contact order. The court may not be listening to you and you don't know what to do. So if that's your situation, you're interested in this area of the law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and my law firm has been defending people charged with crimes for more than 20 years all throughout Washington state. And we often run into the situation where the alleged victim in a misdemeanor assault case, a misdemeanor DV case, does not want the no contact order that the court issued. And it's very frustrating for the alleged victim. And I've learned a few things over my 20 years of doing this that that I've heard and observed in court that are maybe better arguments than others. And so if you find this video useful, please like and please subscribe. More people will get the information they need. There's not a lot out there. So I'm just going to jump right into it. Now, none of this is a legal advice. This is just education. It's my observation. But I think there are some things that are more likely to be useful in arguing to a court. If an alleged victim is making an argument, if she is or he is, because both parties can be victims and protected, in trying to get the order dropped. And I think the first thing that can be said is, hey, I never asked for the order to begin with, right? I know how to protect myself. I never asked for the order. There hasn't been problems like this in the past, if that's true. And this order is super inconvenient for me. I simply don't need the protection, that I'm not under the power and control of the defendant. I have my own job, I make my own money, those type of things. And so, Judge, I appreciate what you have to say and that you issued the order to protect me, but I really don't need it and I don't want it. And could you please terminate it at this time? Now, that may or may not work because the court is often early on not going to want to terminate the order, try to protect the court, right? To protect themselves. Everybody's self-interested. They want to err on the side of protecting the victim. But the stronger that an alleged victim sounds and presents of not needing the court's help, the more impression is made on the court that person knows how to take care of themselves, the better chance there is that the court will listen, right? And I love her, I need her, I want her type things from a male alleged victim isn't necessarily going to help, because it sort of activates some victim protection mode in the court, from what I've seen. So the first thing is, hey, I didn't ask for it to begin with, but thank you, I know how to take care of myself. I think the second thing, and I learned this, a protected party, told this to me. In this case, she told me, Lance, it's really disempowering. The court is really disempowering me, and I feel re-victimized by the court, that I'm not being listened to. I never really thought of that before, but I think that's a pretty good argument. That, hey, court, thank you for protecting me, but by not listening to me in the past, I feel disempowered. I'm an adult. I know how to take care of myself, and I know you're doing things for good reasons, but could you please respect my wishes and let me have my power back to decide what happens in my life, right? Just because my partner got arrested doesn't mean that I give up my right to decide what happens with my life, right? Who says that you know best? Now, might want to not put it exactly that way, but it's that type of passion that I think that the court really hasn't seen that argument very much, right? I think that can be a good argument to the court that don't disempower me, right? There's plenty of good reasons why you protected me, and here's some reasons why I don't need it. Maybe I've learned that the defendant's done some classes and has educated him or herself. Maybe I've learned from speaking to the advocate that I have a safety plan now. I have a safety plan, so I know what to do in the future if there's a problem. Maybe I've learned about what needs to happen in the future, and I didn't know that before. So empower me to make my own decisions. Because I don't want this order anymore, if that's the case. So I think that could be useful. And I think the third thing that can be useful, I sort of jumped into a bit there, is pointing out to the court how things are different today, right? Let's say you're going in for an order drop hearing, you requested to drop the order, you got a hold of the advocate, they set you a hearing, And you have learned that the defendant's enrolled in DVMRT classes or has done anger management classes. Those are things that are different than the first day probably that the order was issued. And there's a reason why the judge should feel better about terminating the order now. And you can also tell the court, hey, I know how to ask for one again. I've spoken to the advocate. I've gotten my education about what to do. So, things are different. I'm a different person now than I was a month ago. And let's just jump into a little bonus here. I think, let's say the situation is that nobody got arrested and, 6 or 8 weeks later that the defendant gets a summons to show up in the mail, and now you're going to court to say, Judge, don't issue a no contact order to begin with, right? You're trying to avoid it. Well, it could be a good argument, in my opinion, to point out, look, it's been 8 weeks and there haven't been any problems, right? If the state or the city was so worried about protecting me, why didn't they file this 8 weeks ago, right? Maybe we've done some counseling, maybe things are better, and I appreciate it, but I don't need this order. So again, these are observations. This is education. I can't advise you what to do. If you need victim representation, my firm does do that type of thing. Oftentimes we suggest that it might be better to do on your own, because sometimes an emotional plea comes better directly from the protected party than an attorney, but sometimes you need that help. So I hope you found this useful. If so, please like and please subscribe. More people will get the help they need. And more importantly, if you're in this situation, if you're trying to terminate a no contact order, either on the alleged victim side or even on the defendant side, we hopefully are able to help. So you can always reach out to us, give us a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.